Well, here we are again, folks. More discussions of the Supremes, some of their rulings on education law litigation. Today's topic is separate school, denominational school employment. If you teach in a separate school or denominational school in Canada, you're in a different situation than people who are just teaching in a regular public school. There's certain things that can get you into trouble that can't get the rest of us into trouble. And I thought I should spend some time explaining why that is. And we have to go back to looking at the Constitution. Remember that already we've done a discussion of the Constitution Act, the BNA Act, sections 93 and 95 of the, or not 95, sorry, but anyway, the section, the Denominational Schools section of section 93 of the Constitution. I would suggest looking, or if you haven't already listened to that, go back and listen to it, and you'll get a better idea of how things work across Canada with regard to denominational schools. Just remember, though, that our Constitution is now, since 1982, it's not just the BNA Act, which is the original 1867 Constitution Act, right, where you found protections for denominational schools, but also it includes the Charter of Rights and Freedoms, all right? And in the Charter of Rights and Freedoms, there is a section 29, and that section reads, "Nothing in this charter abrogates or derogates from any rights or privileges guaranteed by or under the Constitution of Canada in respect of denominational, separate, or dissentient schools." So in other words, when you look at the particular section 93 of the Canadian Constitution, the former BNA Act, which stipulates that there are protections for denominational schools in Canada, with the coming of the Charter, that doesn't mean that those protections no longer apply. So where, if Section 93 didn't exist, where there were those protections in the BNA Act, if that didn't exist, and then, a Catholic school were to fire you for, not upholding certain, religious dogmas or doing something that's contrary to church orthodoxy, nowadays with that would obviously be a violation of your chartered rights, right? I mean, it's discrimination on the basis of religion, but that doesn't work because we have section 29 of the Charter that says that everybody's got these rights, but remember that the Charter does not trump the other parts of the Constitution. All right, there's this other part of the Constitution that's foundational. That's the bit that Canada's founded on. It's the stuff that's been around ever since 1867. We have to respect that. It's part of our heritage. It's part of what makes Canada Canada. All right, so just that's something. When you in this lecture, you'll see how significant Section 29 is. Here's Section 93. We've looked at it in greater detail in the earlier lecture on the Constitution Act, and Section 92 on the provincial jurisdiction over education, and Section 93 on education specifically. I'm not going to go into it in great detail. You can read through it, or you can listen to the previous lecture. But this is the section that basically says that dissentient or separate schools or denominational schools have a right to exist where they existed when a province entered into confederation. What does that mean? Well, it can mean different things, right? So if you teach at a Catholic school, you're beholden then to Catholic doctrine, to not just in school but even outside of school, and that because it's a denominational school, the school board is entitled to, get rid of you if you aren't behaving like a good Catholic. Okay, so here's an example from 1984 that went all the way to the Supreme Court. So here's the Supremes. Caldwell v. Stewart. A Roman Catholic teacher in a Roman Catholic school was not rehired for the following school year as she had married a divorced man in a civil ceremony contrary to church dogma. These proceedings were initiated through a formal complaint under British Columbia's Human Rights Code alleging dismissal without reasonable cause and discrimination against appellant on the basis of marital status and religion. Like, if this was, in other words, if this was a regular public school, right? It wasn't a Catholic school. It was just a secular school. You could never do that. That would be a total violation of your rights. But it's a Catholic school. It's a separate school. Separate schools, denominational schools, are protected under Section 93 of the BNA Act of the modern, and also of the modern day 1982 Constitution Act. So it's allowed, right? At issue is whether or not it's contrary to the code for a denominational school to refuse to hire a teacher who has personally disregarded church teachings. And the Supreme Court of Canada held that conformity to Roman Catholic religious practices is a bona fide requirement of teachers in a Roman Catholic school. Okay, so be aware of that. That if you were to teach in a Roman Catholic school, there's many wonderful Roman Catholic schools. I've supervised student teachers in Roman Catholic schools. Excellent places to work. Lots of great teachers. Lots of great students. Lots of great administrators. But be aware that these are considerations. Walsh v. Newfoundland. This is a 1988 case. Newfoundland entered Confederation quite a bit later than the other provinces, and when it entered, it had its own long-standing denominational school system. Not so much, all just Catholics. There was all different denominations that had charge over delivering education in Newfoundland, and one of them was the Salvation Army, believe it or not. So here you have Mr. Walsh. He was a long-standing Roman Catholic at the time he was employed, but later became a member of the Salvation Army and married a woman from his newly chosen faith. So he worked at a Catholic school, right? But he switched. He was dismissed from his teaching position because he failed to continue to uphold the bona fide qualification required at the time of his employment. It was argued that he could no longer be an appropriate religious role model for his students because he had, by example, repudiated Roman Catholic doctrine. Now, Mr. Walsh contended that he was willing and able to teach the Roman Catholic religion to his students because he had been a practicing Catholic for 28 years. Roman Catholic Board claimed that he could not be a living example of the faith because of his actions in private life. When Mr. Walsh contended that his human rights had been violated under the Charter of Rights and Freedoms, the judge ruled against him. Okay, so you don't have a lot of choice. I mean, you have choice. You can, but then you have to suffer the consequences. There's no way to get your job secure in this situation. He had no recompense, I guess. So, like in Calder, an educationally competent teacher was dismissed for failing to uphold bona fide religious qualification. Here's another important trend-setting court case from 1987. Casagrande v. Hinton, Roman Catholic School Board. In 1986, the Roman Catholic School Board of Hinton, Alberta, was accused of violating a teacher's charter rights by interfering in her private life and discriminating against her on the basis of sex. Miss Casagrande was dismissed from her teaching position when she became pregnant out of wedlock for a second time. The school board argued that Miss Casagrande failed to live up to Roman Catholic doctrine by engaging in premarital sexual intercourse. That's pretty snoopy stuff, isn't it? But this is it. The ensuing pregnancy was an indicator of this inappropriate lifestyle, but it was the lifestyle that was objectionable, not the pregnancy, they said. The judge sided with the school board. He indicated that teachers must behave morally in their private lives as well as on the job. Interesting, right? I have a whole lecture I'll do for you on the idea of teachers as role models and how, other jobs, we go to work, we work 9 to 5, we're at work. Our work life is separate from our home life. It's not the case as a teacher, folks. Things that you do off duty, things that you do outside of the classroom on your own time, they can come back to bite you in the arse as it is, right? As a teacher. And I mean, here you are at a Roman Catholic school where they, premarital sex is forbidden, and you have premarital sex. Not that this is an unusual thing. Premarital sex is quite common. It's not even necessarily anything that anybody has a problem with, but it's against Roman Catholic doctrine, and you work in a Roman Catholic school, it's on your own time, you get fired, right? So the judge sided with the school board. He said that you have to behave well in your private life. In his view, this was not a case of sexual discrimination because the lifestyle attributed to Miss Casagrande could also be adopted by male teachers. Both males and females must abide by the same denominational doctrine. Yeah. The ruling indicates that all Roman Catholic school teachers must live a lifestyle consistent with the religious doctrine of the Roman Catholic Church. So this ruling shows that what a Roman Catholic teacher does in his or her own private life may be the cause for dismissal, even though it doesn't involve marriage outside the church. This precedent, based on lifestyle, may also form the basis for rulings made in cases concerned with teacher behavior in public schools. So an important case, 1987. Here's another one. Metropolitan Toronto Separate School Board v. Ontario English Catholic Teachers Association. A highly qualified teacher of religious studies was punished for her off-duty publications advocating equality for women in the church. Her out-of-school writing and media statements were thought to be too controversial in their criticism of the church hierarchy. Consequently, she was denied a job as department head, which she had previously held, and for which she was best qualified. She was also taken out of her position teaching religious studies and placed teaching English and history instead. All right, so this is what they did at her school. She worked at a Catholic school. The arbitration board ruled in her favor, interestingly enough, saying there was no rational administrative basis for the school board's actions against her. The teacher had behaved according to Catholic Church doctrines during all of her teaching duties, and she taught the children in her care according to church doctrines. Moreover, they noted there was, and continues to be, much debate among learned Catholics concerning the role of women in the church. So, they said here that, I guess there are a number of bishops and people like this who have divergent ideas on the role of women in the church and the place of women in church leadership and this, and therefore, it wasn't as black and white of an issue in Catholic doctrine as was being made out by the school board, right? And the school board's actions were found clearly disciplinary and politically motivated, not denominational in this case. So their motion to punish the teacher was struck down by the court. That's an interesting one. Essex County Roman Catholic Separate School Board v. Porter, 1978. The Ontario Court of Appeal decided that 2 teachers who entered civil marriages and were fired for doing so had no right to have their dismissal reviewed, right? So they got fired. The teachers wanted to have that situation reviewed, and then they were denied the opportunity to have a review, and then the Court of Appeal said, yep, you don't have to have a review. This is a dead issue. If you marry in a way that the church doesn't like, then they can get rid of you at a Catholic school. Black v. Metropolitan Separate School Board, 1988. The Ontario court ruled it's okay to fire a teacher in the Roman Catholic system because she didn't direct her education taxes to the separate school board. That's an interesting one. It had nothing to do with her teaching or anything like that. It's that she didn't actually pay her education taxes toward the separate school board. She put them towards the public school board instead, and they canned her. And they said that was okay. Wow. OEC TA v. Dufferin Peel Roman Catholic Separate School Board. They ruled it's okay for a board not to promote non-Catholics who are well or best qualified, right? So the fact that you're a Catholic or not a Catholic, look, a Catholic school board can hire non-Catholics. It's just that they're under no obligation to. That preference goes to Catholics when Catholics are available, and even if you're not as qualified or you wouldn't even make as good of a teacher as this non-Catholic person, it doesn't matter. They can pick on the basis of religion, which again anywhere else would be totally discriminatory. It would be a violation of the Charter of Rights and Freedoms, right? But with this, because it's protected, right? Section 29 Charter says that you can't. The Charter doesn't override the BNA Act or the Constitution Act in Section 93. This is allowable. Okay. Now I included Hallbe Powers. I think it's a really interesting case. It doesn't have to do with teachers and employment of teachers in Catholic schools, but it does have to do with Catholic schools. So, I mean, just remember, all what we've talked about so far shows how teachers are held to a real high account for, so-called morality reasons, or at least doctrinal reasons in Catholic schools, and that if you don't follow doctrine, you can get canned, and there's little you can do about it because that's the way it is. But it's not the same if you're a student. Okay, the Hallbe Powers makes that pretty clear. In fact, I mean, look, my wife went to high school in Newfoundland, and in Newfoundland she went to a Catholic school. Like, as I was saying, the schools out there were all administered by various churches and her and her sister went to Catholic school. They're not Catholic. And likewise, the kid down the street from us, he's not Catholic. He goes to a Catholic school. I know a number of kids who are Catholic, don't go to Catholics, but go to Catholic school. When I was a kid in Ontario, that's where I grew up, I had friends who went to Catholic school, I guess because their parents thought it would be a better education there, but they went there. They weren't Catholic, right? So they're held to a different level of expectation as students than we are as teachers. Now, Mark Hall, he's an interesting case because he was a 17-year-old Roman Catholic Oshawa High School student. Like, he was Catholic, right? And he was attending grade 12 at Monsignor John Pirema Catholic Secondary School. This was his school since grade 9, and prior to that, he even attended Catholic elementary and junior high school. So he's always been, this is his faith, this is his tradition. He also came out to his parents and his friends and his school peers. He told them all that he was gay. All right, now, the Catholic Church has a certain position on gay and lesbian people, and what they would consider, the morality issues surrounding, sex out of marriage and gender and all these things. I don't want to get into that too much, but in the Catholic understanding, dogmatically, that is looked down on. And so here you have, Mark, he's been his whole life in the Roman Catholic tradition. He's been going to school there ever since ever. He goes to annual prom, right? He goes his last year, right, to celebrate having gone through, going to graduate. It's an off-site party. It's a dance held in honor of the grade 12 students, just like all the other kids he wants to go to, right? But he wants to bring his same-sex boyfriend, right, to the prom, and this is a significant social event in the lives of those students. It marks the end of their formal education, but he's barred from this by the school's principal from attending the grade 12 prom because he wants to bring his same-sex date. In this case, both the principal and school authorities were complying with the orthodox dictates of Catholic social thought, right? Like, that's what Catholic social thought in its orthodox form states, so that's what we do because we're a Catholic school. Having the responsibility to manage their schools in a way that fosters what church authorities have decided constitutes a genuine Catholic education, they align their decision in this matter with the official position of the Roman Catholic Church, following specific directives handed to them by the bishop for that area, right? The Durham region. So they're just doing what Catholics do, officially by the book kind of stuff. Now it's important to note, I thought it was important to note anyway at this point, that exclusion from school proms occurs regularly at both denominational as well as non-denominational public schools throughout Canada. School authorities may bar students from attending prom out of safety concerns about troublemakers. You can bar students because they refuse to wear the appropriate clothing to a prom, believe it or not. You can bar them also as follow-up consequences for past student behaviors, or even when students haven't paid their school fees. All right, kids can be kept away from the prom for any number of reasons. And on such bases, the exclusion of students from graduation dances is certainly not uncommon, nor is exclusion from prom considered to wreak irreparable harm upon students. Like, I've taught myself, and I know of cases where students weren't allowed to go to the prom for any of the above reasons. However, it's also the case that in a public school setting where denominational concerns are afforded no constitutional protections, any discriminatory exclusion on the basis of sexual orientation would obviously be impermissible. It would be a violation of Section 15.1 of the Charter of Rights and Freedoms, right? Like, just would never happen. That would be repugnant, right? To keep somebody away from the prom because, he wanted to take his boyfriend, or because she wanted to take her girlfriend. It just wouldn't happen. Now, interestingly enough, this is a sidebar to Section 15.1. I don't know how many of you are familiar with it, but I'll just read it to you. Every individual is equal before and under the law and has the right to equal protection and equal benefit of law without discrimination, and in particular without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. You'll notice that sexual orientation is not there. This is an interesting point, that when the Trudeau government and the Parliamentary Committee on the Constitution when this was being crafted, the groups who were involved in the crafting of Section 15.1 of the Charter, when they were present, they repeatedly rejected requests by gay rights activists to include sexual orientation in the wording. All right, so it was purposely let out. One of the reasons why I've heard when I was studying political science as a grad student was that it's kind of like in that Disney movie, The Incredibles. I don't know if you've ever seen that, but where the bad guy says, if everybody has superpowers, or if everybody's super, then nobody's super, right? So just like the bad guy says there, the other groups, like the women's groups there, and the groups supporting equal rights on the basis of race and things like this, they said, well, we want this to be a powerful section, and if the more groups it protects, the more groups Section 15.1 protects, the more dilute, they feared, the more dilute its power will be. If these group rights in Section 15.1 were afforded to everyone, then they would really be afforded to nobody. If everyone's special, then nobody's special, essentially, like the bad guy. I can't remember the bad guy's name in The Incredibles. Anyway, it's kind of like that. Needless to say, then, or not needless to say, but what ended up happening was in 1995, there was this really big court case that went to the Supreme Court of Canada, the Egan case. And even though it's been a long time since I read that case, but even though I think Egan was unsuccessful, it was a gay rights case. Even though he was unsuccessful, nonetheless, it was like he had the real big victory there for gay rights was that the courts actually read in to the legislation something that was never intended by the legislation. Namely, they read in sexual orientation into Section 15.1. So it doesn't appear in legislation, but it's judge-made law. So it's actually constitutionally valid. It's something that's part of the Canadian Constitution now, brought down by the Supreme Court of Canada. It's part of our law now ever since 1995, that sexual orientation is part of the equality rights section of the Charter of Rights and Freedoms, okay? Okay, so the judge ruled against Principal Powers and Catholic school authorities, in this case, on the grounds that their refusal to allow the boy to attend prom violated his equality rights, and that this infringement was not constitutionally protected by the denominational school guarantees provided by Section 93 of the BNA Act. This is kind of sneaky. The judge bypassed the views of the bishop and dismissed established Catholic Church doctrine on homosexuality. He turned to popular opinion instead and diverse views of ordinary Catholic laity. So, I mean, what he did was, even though established church doctrine, Catholic Church doctrine, has this pretty clear position on homosexuality, like it or not, repugnant as it is to many people who are not, church dogmatists, that is what it is. It is what it is. And not only that, but you've got the bishop of the whole area, who's like a formal, he's the expert in these matters. Now the judge is stepping into theology and making dismissive comments about it and saying that the school, a Catholic school, has no ability to act upon established church doctrine. It's very strange. I would say this is a very, very strange court case. And the idea that the judge should be able to, step into the realm of theology and make judgments about, theology in a school that, whose activities are in fact protected by Section 93 when it comes to church doctrine, right? It's very strange. Anyway, the judge, this is how he got out of it. He ruled that denominational schools don't even have a constitutional right to manage events, school events like grade 12 proms, according to doctrinal edicts. Why? McKinnon points out that at the time of Confederation, there were no proms or graduation dances. And unsurprisingly, there's no explicit mention of the power of denominational schools to manage school dances made anywhere in the founding documents of Canada. What do you expect, that they're going to have a section of the Canadian Constitution about who's in charge of school dances? But you can read the court case. It's a very strange one. And another thing that's I found kind of weird about the court case was that the judge also said that barring Mark from attending would cause him, quote, irreparable harm. Well, yeah, it would be hurtful, right? It would be hurtful that he wouldn't be allowed to attend a Catholic school prom with his boyfriend. I mean, everybody else, it's unfair. It's totally unfair. And yet, how many kids, in my experience as a teacher, are barred from prom for any number of reasons? I mean, why is this irreparable harm that you can't go to that you can't go to the dance? Very often, we make decisions to stand up for what's right, and there are consequences for standing up for what's right. And is it irreparable harm? Anyway, to me, it strikes me as a strange statement that this is irreparable harm. Because if it's irreparable harm, then is it irreparable harm for anyone under any circumstances to ever be not allowed to go to the school dance, or rather, the prom, the grade 12 prom? But this is the Hallbe Powers court case. So I'll leave that with you. Maybe you will read it yourself and have a different take on it, and that's fine. But just notice how different it is to be a teacher versus to be a student at a Catholic school. I guess we as teachers need to decide, would we feel, given our own feelings or our own convictions or understandings of things, would we be comfortable teaching at a Catholic school if we're not Catholic? Or even if we are Catholic, are we that kind of Catholic, right? And if you're not comfortable, then quite simply don't work there. That seems to be easy enough to say, but what about in the case of Mark Hall, right? Like, if you're a young, gay man who has been a dutiful Catholic, but also was aware of official church edicts, and you find yourself wanting to do and wanting to go to a prom, but you also maybe you want to stand up for what you feel is right. What are the sorts of things that's incumbent upon you to do as a student? Do you is it your right as a student who is gay to attend a Catholic school prom with your same-sex partner? Or is it, if you want to go to the same-sex, or if you want to go with a same-sex partner to a prom, should you maybe have thought about whether or not you should be attending a Catholic school if that's what you want? Like, maybe you'd be better off going to a public school where that's not expected, that's not part of church. Anyway, the point is moot now anyway, because the court has ruled that this is an unacceptable violation of Mark Hall's rights. And they were trying to do the right thing there. It's just, I wonder what the repercussions are for that. Like, are you allowed, therefore, to believe whatever you want to believe, or to have your church doctrines or dogmas which are discriminatory, as long as you don't act on them? Is that the message that the courts are ultimately sending about denominational rights protections in Canadian education law? Anyway, it's a very controversial topic. I'm sure that there's lots of room on either side for discussion and debate on this, and maybe you'll have some of that in your own class. Thank you for listening.